Now, Bob Mueller was named special counsel on May the 17th, 2017. 1 day later, Mr. Horowitz, 1 day later, Peter Strzok is back on his phone texting some more. For me, in this case, I personally have a sense of unfinished business. I unleashed it with the Clinton email investigation. Now I need to fix it and finish it. Fix what?
Well, there is outlined in the report what Mr. Strzok's explanation for.
Oh, I know what he said.
Was.
I'm asking the guy who had a distinguished career in the Southern District of New York and had a distinguished career at the Department of Justice. Would you rather cross-examine Peter Strzok on that explanation, or would you rather direct the examination on that explanation?
Probably cross-examine.
That's what I thought. How about finish it? When he said, I unleashed it, now I need to fix it and finish it. What do you think he meant by finish it?
I think in the context of the emails that occurred in August and the prior August that you outlined, I think a reasonable explanation of it, or a reasonable inference of that, is that he believed he would use or potentially use his official authority to take action.
But this is 24 hours into him being put on the Mueller probe. There's no way he possibly could have prejudged the outcome of the investigation. Maybe he did. Maybe that's the outcome determinative bias that my Democrat friends have such a hard time finding. Inspector General Horowitz, if one of your investigators talked about Lisa Page and Peter Strzok the way they talked about Donald Trump, would you have left them on the IG investigation?
No.
Did you ever have an agent when you were a prosecutor with this level of bias?
You know, as I've laid out, it was completely antithetical to the core values of the department and extremely serious.
Can you speak up, please?
I'm sorry.
I heard you. But you can say it where Mr. Nadler can hear you, too.
You know, my view of this was that this was extremely serious, completely antithetical to the core values. In my personal view, having been a prosecutor and worked with FBI agents, I can't imagine FBI agents suggesting even that they might use their powers to investigate, frankly, any candidate for any office.
Well, I can't either. And let me ask you this in conclusion. I think you've already, you laid out in your opening that Peter Strzok's obsession with Donald Trump and the Russia investigation may have led him to take his eyes off of the Wiener laptop and in a notably ironic way caused Jim Comey to be a little bit later in sending those letters to Congress. So that is one example of outcome determinative bias. But I got to ask you, you used to be in a courtroom. You were on the side of the United States and you worked for the Department of Justice. If someone is prejudging the outcome of an investigation before it ends, and someone is prejudging the outcome of an investigation before it even begins, what is more textbook bias than prejudging this investigation before it's over and this one before it begins? I am struggling to find a better example of outcome determinative bias than that. So what am I missing?
Well, I think certainly with regard to the Russia investigation you mentioned, as you know, we are looking at that in an ongoing way. With regard to the Clinton email investigation, I think as we lay out here and go through it, we looked at text messages, emails, documents to try and assess whether the specific decisions that we were asked to look at and then the ultimate prosecutorial decision were impacted by Strzok, Page, and the others' views. And what we ended up finding, particularly as to the prosecutor's decision, was that was a decision they made exercising their discretion on their view of the policy, the law, and the facts as it was found. We've laid that out, and in our view, we didn't find or see evidence that the prosecutors were impacted by that bias. But as I mentioned in my opening statement, the idea here was to put out the facts. for the public, members of Congress to see, and so that folks who want to take a look at those issues obviously can assess them themselves.
Well, my time is up. I hope one of my other colleagues will explore that, because the explanation I've heard is that the failure to prosecute was predicated upon their belief that there was not sufficient evidence of intent on her behalf. And I don't know where in the hell you would go to find better evidence of intent than interviewing the person who actually was doing the intending. And when you make up your mind that you're not going to charge someone, and you make up your mind that you need to not go in loaded for bear, and then you read the 302 and there's not a single damn question on intent, it is really hard for those of us who used to do this for a living to not conclude they'd made up their mind on intent before they even bothered to talk to the single best repository of intent evidence, which would be her. With that, I would